Morning, Council. I think I've got the notice that we're live, so we'll go ahead and get started. Welcome to the January 11th docket of the Kansas Court of... All right. I may have jumped ahead a little bit, so I'll start over again. Good morning, Council. Welcome to the January 11th docket of the Kansas Court of Appeals. My name is Amy Klein, and I'm going to be presiding over today's appearances. With me, I have two very distinguished judges, Judge Henry Green, who's the longest serving member of our court, and Judge Patrick McEnany, who was a full-time judge on our court for many years and now serves as a senior judge. So with that, I'm going to call our first case, which is number 123-464, Bryce and Casey Loyd versus the Rural Water District number 2. May I have the appearances of counsel, please?
May it please the court, I'm Jonathan Sternberg and I represent the appellants Bryce and Casey Loyd.
Thank you.
May it please the court, Your Honors, this is Todd Luckman appearing on behalf of Rural Water District number 2, Jefferson County, Kansas.
Thank you. Mr. Sternberg, did you want to reserve any time for rebuttal?
Yeah, three minutes.
Okay. You got it. And I have that today's arguments are set for 15 minutes. Is that what you both have?
Yes, Your Honor.
Yes.
Okay, great. And because this is on YouTube, can you, Mr. Sternberg, provide just a little overview of the case for those who may view it later? It's not gonna cut into your time, but it will kind of help orient people if they may be tuning in. So
Sure.
if you can do that, that would be great. And if everybody's ready, then counsel, you may proceed.
Thank you. All right, well, before I introduce myself and start in on my argument, then I'll make a little synopsis. I represent a husband and wife from Jefferson County, Kansas, who purchased some farm property a few years ago that was supposed to have 2 benefit units from the local water district. And those are membership units in the district that entitle it to 2 water services from the local water district. And those are interests in the property that run with the land. They get sold along with the land unless they're specifically carved out. But my clients alleged that the district transferred away one of those units to an adjacent property unlawfully, and then refused to allow my clients to inspect records for, as the bylaws of the water district stated, or to issue certificates for their benefit units as the bylaws also required. My clients, in response to this, sought a writ of mandamus, which is an order from a court compelling the water district to do so. And after some protracted litigation, the district ultimately made something called an offer of judgment to agree to say that my clients did own the benefit units and that they would issue the certificates. And my clients accepted that offer. But then my clients sought attorney fees and costs under several Kansas statutes that I'm sure we'll talk about. And after a briefing and argument about that, the district court denied their request for attorney fees and costs. And my clients are appealing the denial of the attorney fees and costs. And with that, may it please the court, I'm Jonathan Sternberg and I represent the appellants Bryce and Casey Loyd. As I just said, the Lloyds appeal from a journal entry denying their requests for costs and attorney fees after judgment was entered for them in their mandamus action upon their acceptance of the defendant's offer of judgment. Your Honors, the district court's holding that the Lloyds were not entitled to award of their costs and fees was error. This court should reverse the trial court's judgment and remand this case for a determination of those costs and fees. As this court explained in the Richardson case, it's Richardson versus Murray from this court in 2017, a published decision that we all talked about in our briefs. Under KSA 60-2002B, the law of Kansas, echoing uniform federal law under Federal Rule of Civil Procedure 68, is that when a plaintiff accepts a defendant's offer of judgment in a case in which a statute or a contract allows a prevailing plaintiff attorney fees, and the plaintiff's petition seeks fees, but the defendant's offer doesn't state that it carves those out, that it includes the costs or fees, the plaintiff remains entitled to costs and attorney fees because by making the offer of judgment, the defendant has admitted the plaintiff's entire action, as this court said in the Richardson case, as if it were a consent judgment. In Richardson, this court reversed a district court's judgment refusing costs and attorney fees in that circumstance. And well, Your Honors, that's exactly the same thing that happened here. After the Rural Water District transferred away one of the Lloyd's 2 benefit units to the land they purchased to an adjacent property, and the district refused to allow them to inspect the books or issue them certificates for their benefit units, as the district court's bylaws required, and frankly, as the district admitted in its answer, even outside the offer of judgment, they brought a mandamus action to compel the district to do so. After protracted litigation, the district ultimately made an offer of judgment, just like in Richardson, to issue the certificate and confirm the Lloyds did own the benefit unit it had taken away from them, and the Lloyds accepted the offer. But by doing this, as the Loyds explained as the court explained in Richardson, the district admitted all of the Loyds' allegations in their petition. And that's exactly what Richardson holds. And the defendants pay very short shrift to that in their brief. It says, by voluntarily, this is the court in Richardson, by voluntarily submitting an offer of judgment, a defendant allows judgment to be taken against him or her to the effect specified in the offer based on the pleadings and the evidence in the record, and makes that akin to a consent judgment. Well, costs is straightforward. KSA 60-2002A, and I don't think the defendants really contest this in their brief, entitled the Loyds to an award of their costs as in any civil action. And as the court ordered in Richardson, they had to be allowed costs, and denying them was error. In our brief, we cite the Golanda screw case from this court in 1995, which held that costs under that statute have to simply be taxed automatically to any prevailing plaintiff. And obviously, we are the prevailing plaintiff, and I don't think they disagree with that. So at the very least, the district court's judgment was error in that regard. Attorney fees, though, despite our 60 pages of briefing and as belabored as we've made it, is also pretty darn straightforward. KSA 60-2002A, under the mandamus statute, 6802C, the separate allowance for costs in that statute entitles the Loyds to award their attorney fees. For 120 years, we cite cases going all the way back to 1902, and I'll mention them. For 120 years, Kansas courts have held that costs, the word costs in the mandamus statute, include attorney fees. That's the Barton case in the Supreme Court in 1968, which relied on the McClure case from the Supreme Court in 1902. We list more decisions and those on page 19 of our brief. Now, I appreciate, and this is what the defendants seem to have glommed onto, and the district court did too, that there are some decisions throughout the history, which we discuss in our brief, that hold a public official only can be made personally liable for attorney fees and mandamus as costs under 6802C if their decision was unreasonable, arbitrary, or in bad faith. But the Loyds here weren't seeking to hold the individual board members of Rural Water District Number 2 of Jefferson County personally liable for any attorney fees. Now, I appreciate there are some cases that seem to have expanded that notion over the years to a public body in general. But that's not the Supreme Court's original point in creating this doctrine. That's the Day case from the Supreme Court in 1937 that we quote in our brief. The point to this doctrine about arbitrary, unreasonable, bad faith is, quote, where public officials act reasonably and in good faith, although defeated in a mandamus proceeding, they are properly relieved from personal liability for costs and damages unless the official acts arbitrarily, unfairly, or oppressively. Again, we've made no request to hold the individual board members personally liable for this. We're seeking, the action was only ever made against the board itself in its own name. Sometimes you'll see these actions that have individual members of the board named as well as wrongdoers. We didn't do that. This is about enforcing the bylaws of the organization itself. So this doctrine that the district court glommed onto and the defendants harp on in their brief, which I'll address in a moment too, that we would have to show that their failure was unreasonable, arbitrary, or in bad faith simply doesn't apply here. We are
excuse
entitled.
me.
Yes, Your Honor.
Excuse me. Doesn't the concept, as far as a public official, doesn't that concept also apply to a public a body like the Rural Water District? And I'm looking at Link, and it seems like it would give support to that.
Link does, but Link is relying on prior decisions, and I think this is it's a misapplication of the original purpose of this doctrine. I don't think there's ever been a rationale expressed for why this doctrine has been expanded. Because if you look at these earlier cases like McClure, if you're just suing the body itself or the person in their official capacity as a representative of the body, that doctrine wasn't included. But Your Honor, I appreciate Link and other cases do seem to expand that, which is why belt and suspenders approach here. If we do have to prove that, we certainly did. And I'm happy to address that too.
Counsel, I would like you to address that. I mean, what is the evidence? Because I noticed the district court found specifically that the Rural Water District did not act unreasonably or arbitrarily. Sure. So what evidence is there in the record that would support your position in that regard? Okay,
two responses, Your Honor. First, let's talk first about the law, and then we'll talk about the facts. First, the district court, and now the defendants in their own brief, forget that the real issue here is that by doing the offer of judgment, they have admitted every single allegation in our pleading. They have allowed us to take judgment to the extent of the facts in our pleadings. That's a direct quote from Richardson that I quoted earlier, that this is as if it's a consent judgment. They are simply consenting to everything in our pleading. And frankly, if you look at their own answer, they admitted a whole host of things in our pleading itself. Now, the district court ignored this principle of law entirely. It acted as if we had to have some kind of separate evidence at some kind of separate evidentiary hearing, which it of course held, but we did argue the whole time that this is an acceptance of our own pleading. In their brief, so the district court misapprehended that. The defendants in their brief misapprehend this too. For example, at the very end of their brief, the defendants deny that they even had a ministerial duty to issue benefit certificates. This just shows that they misunderstand what making an offer of judgment means. This wasn't a settlement. We had offered to settle with them many times. Instead of entering into a settlement where we could have hashed all these issues out, they made an offer of judgment, which accepted our pleading. Well, in their own answer, they specifically admitted what they now deny in their brief. Even outside the offer of judgment, they in record 1, page 223, it's their answer. They admit that they had a duty to issue the certificates and that they did not. So the evidence in the record as to what made this unreasonable is the same evidence that would entitle any prevailing party to attorney fees under a statute that allowed for it. For example, in Richardson, you have, we prevail on our KCPA claim, therefore we get fees. Well, here we showed in our pleading that what they did was arbitrary and unreasonable. First of all, the district, and this is, they acknowledge this in their own answer too, but they did it by their offer of judgment. The district was actively involved and well informed about who actually owned these benefit units. Their representative, Charlie Bowen, met with the sellers of the property to my client, the Seatons, and reminded the Seatons, Mr. Bowen, who works for the district, reminded them that the farm had 2 benefit units within its boundaries. Roger Moore, the person who bought the adjacent 50 acres, to whom the district later unlawfully transferred the benefit unit, was a former board member of the district itself. So you have intimate knowledge in the district itself that these benefit units belonged to the Seatons' property. The district then, once it became clear that the district was beginning to treat my clients as if they didn't own this benefit unit, they breached their duty to allow the Loyds to investigate the records concerning the farm's benefit units. Again, this is in our petition. They admitted in their answer. And again, by the offer of judgment, they admitted everything in our pleading too. So they're supposed to allow us to investigate these records. They refused. The district then falsely, and this goes to bad faith and unreasonableness, the district falsely claimed to my clients that it did not know who owned the farm's benefit units. And this is record volume 1, page 172. The board claimed it didn't know who owned the water rights associated with the meters on the farm. They admit that in their answer, record volume 1, pages 224 to 25. They could have quickly confirmed that it had no reservation of the benefit units from the Seatons. So for example, my clients purchased this property from the Seatons. There is no carve out in the sales documents. There's no carve out in the deed saying that we're only selling you 1 benefit unit. And again, this is after the district, Mr. Bowen has already told the Seatons, you guys have 2 units, and if you would need to transfer it. So the district quickly could have confirmed it had no reservation for that. Without a reservation by the Seatons, without moving the meters, title to the benefit units transferred automatically to the Loyds. That's record volume 1, page 207. That's their own bylaws. So these are, again, things of which the district had full knowledge and notice. And then,
but counsel, what about the affidavit? I think it was an affidavit from the Seatons that said, hey, we didn't intend to transfer both of these units to your clients. When we split the properties, we intended one to go to each, I think, 50-acre tract.
That's in the Seatons' own pleading, and that's in evidence that was brought in outside of the pleadings by the defendants. They don't have the right to do that. This is an offer of judgment. That's not considered. What's considered here is what they admit from our pleading. It's as if it's a consent judgment, and that's part of their argument, but it violates that principle.
Are you saying that the water district admitted it did know your clients owned both units? I thought you just said that they admitted they didn't know who owned it because there was this cloud created by the affidavit.
No, that's not what I said at all. So the Seaton's affidavit is in this litigation. There's a letter from the Seatons, but my clients, in response to that letter from the Seatons, and again, this is record volume 1, page 168 to 69, my clients immediately showed the water district all the sales documents. So no, I didn't say the water district didn't know. They most certainly did know. They knew the Seatons had 2 units. There is no evidence in front of the water district that any document of actual legal transfer of title document transferred these. And furthermore, their internal billing records showed that my clients owned these 2 units. And this is record volume 1, pages 101 to 102. There was one billing cycle that transpired between the 2 board meetings that my client, Mr. Loyd, attended, and they could have certainly seen in that time period, who are we billing for the water service? They absolutely did know this, and they falsely claimed that they did not. Then, in terms of arbitrariness, they arbitrarily accredited this statement. Yes.
If you want to keep your time for rebuttal,
Certainly.
then, yeah, I just want to give you an opportunity to wrap it up before we transfer it.
Before you do, just
Yes.
a couple of questions.
Absolutely.
This issue about unreasonableness, clarify for me, is that an issue of fact or an issue of law?
This is an issue of law in these circumstances because we're dealing with the face of the pleadings. This is not, all that matters is what's on the face of the pleadings. It's as if it were a judgment on the pleadings or something like that.
Well, isn't the purpose of, if we limit it just to what's on the face of the pleadings, isn't the purpose of the offer of judgment to end the litigation? And if we're looking at just the face of the pleadings, you want one judgment that ends the litigation. That judgment, you've asked for attorney's fees in that pleading, and that was not included in the offer of judgment. Richardson's fine, but of course we're not bound by Richardson.
Richardson is a published opinion from this court in 2017.
It's a collateral opinion from another panel.
Fair enough, Judge, but Richardson relies on 50 years of federal law, including from the US Supreme Court, about the identical thing. The issue is, once you make an offer of judgment and you don't carve out costs or attorney fees, you're right, it ends the case. It creates a judgment, but it's a judgment as to the merits of the action itself. If there are ancillary things like costs and fees, then that's—
Right, so you're saying you want 2 judgments. You want a judgment on the face of the pleading, and then you want a separate judgment for fees, which you asked for in the pleading, right?
Judge, it's no different than if let's say it's a breach of contract case and we go to a jury and the jury determines that we have prevailed in our breach of contract claim and gives us damages. Then after that, and then the judge enters an order confirming that, then after that, we go to the judge and ask for fees. This is no different. The issue is, this is like a verdict. This is like a verdict on our mandamus action, and then we get to go ask for fees and costs. That's how an offer of judgment works. But it is limited to the pleadings itself. So in this circumstance, it's a question of law, absolutely.
All right.
I'll save the rest of my time for rebuttal. Thank you, Your Honors.
Does any other questions for the panel before we move on?
Thank you.
Thank you.
May it please the court, is it my time to begin?
Let me get you back up to 15 on my timer, because I don't think you won only 12.
Yes. Thank
All
you.
right, yes, you may begin. Thank you, counsel.
Thank you, Your Honor. I think at first we've got to correct the record here, at least as far as what actually happened in this case. I appreciate the advocacy that draws out the best parts of the Loyd's case, but that's really not what happened, what was just related to. What was actually happening was the Seatons and the Loyds were in a hot legal dispute about the ownership of that second benefit unit. The case of mandamus was an amendment to the pleading that happened well after, almost a year after the case was filed. The case was originally filed in March of 2019 that named the Loyds as plaintiffs, the Seatons as defendants, and Rural Water District Number 2. Of the 4 counts that were brought in the case, only 1 count was addressed specifically to the district. The district was not involved in counts 1 and 3 and were not blamed at all for the issue of the problem of the transfer of the existing benefit unit. The fourth cause of action was to examine the books and records of the district. Now, the district did not answer or respond with legal counsel at that time, erroneously believing that they merely had to show up in court at some time, produce the records they had, and show the court what exactly they saw as happening, which is that two parties claimed an interest in the same benefit unit. The one benefit unit with the property that was normally attached to the household was transferred. The other one was disputed. And the court correctly pointed out that the key piece of this was a statement in December of 2018, I believe, that said essentially that the Setons claimed that they never transferred the benefit unit, the second benefit unit, to the Loyds. That's why the Loyds sued the Setons. They sued them first and fully expected and tried to get a judgment against them to force them to transfer that second benefit unit. That matter was at issue throughout the majority of the time this case was in effect. There were only answers, there were no discovery, there were no other pleadings, there were no motions, up until the point there was a motion to dismiss finally heard in October of 2019, which was the hearing where the Setons rightfully claimed that the very sale documents that are the core of this transaction said that they had to mediate before they could go to court. And the judge agreed, and that's what it said. So now the Loyds are without recourse. So, but at that hearing, Judge Nafziger pointedly says to counsel for the Loyds, says, what you really want here, because at that time the Setons had relented on the record saying, we don't own the second unit, we were wrong, give it to the Loyds. The court said, you know, you want two certificates, right? Why don't you get default judgment against the district that just says you get the two certificates? In which the attorney for the Loyd said, yes, well, that's great. We would like that. Now, instead of doing that, they entirely switch course. They file an amended pleading with the mandamus direction. And by that point, counsel for the district considers the fact that perhaps we can still resolve this according to the terms that everybody's talking about, because we don't have any way now to deny the fact, since it was cleared up after the statement that was made that said the Setons owned one of them, that they relented. Now we have no reason not to do that. So we would offer judgment for the two certificates and give them the two certificates. And I would note for the court, the only two people in rural water district number 2 that have certificates right now, I believe, are the Loyds. No one else in the district, despite owning benefit units, has a certificate. So at that point, and I think this goes to the core of what Richardson says and what the statute says about these offers, and which is just glided over in this, which is it's not just an examination of the pleadings. It's an examination of the offer. And what it says is the effect specified in the offer. So we offered basically really only one term, but separated into two. We said, we will issue you two certificates and we will recognize the fact that you, the Loyds, are owners of both of them. Now that we've had it cleared up through this other part of it, that you are actually the owners. And that then resulted in the case before us. And I would note for the record, Your Honor, it's pretty clear that up until the point of the $50,000 we're talking about in attorney's fees, the vast, vast majority of these fees were incurred before that amended pleading. That amended pleading was done, an answer was submitted, and then the offer followed. We are at a bit of disadvantage here in about discussing the fraud of the district and what the district knew and what it didn't know and what happened in this case, because we don't have a record. We have $50,000 worth of fees in a case that had nothing but motions to dismiss and answers, didn't have one scrap of discovery, didn't have one deposition, didn't have a trial, didn't have anything other than that, those 2 hearings, which should not result in this type of award, especially when it's clear the dispute started because the Setons and the Lloyds could not agree. And more to the point, they couldn't point to any document that they had in the sales record that showed that they had transferred both benefit units. I think there's also some things the court should understand about benefit units and water districts and how they treat them, because there's a lot of language that is said in the brief for the plaintiffs that talk about how this should be automatic. That these certificates are crucial, that these are very important things. And they're trying to twist things a bit by talking about this as an automatic thing when they're really talking about transferring an item, a piece of property from one party to another. It is the case that water districts can create new benefit units and issue them. That's not what we're talking about here. The Lloyds did not want a new benefit unit. They wanted the benefit unit that the Setons owned. That was it. And when you talk about a transfer, things change. The district has, in its own discretion, the ability to issue new benefit units. Now, when it comes to a transfer, the court in Didecki clearly stated that the district has to respect the right of the owner of the property and the owner of the benefit unit as a due process right. You cannot deny them the rights under the benefit unit without giving them a chance of a notice and a hearing about any effect you're going to have. If the district is going to cancel you for non-payment, you have to have a notice and a hearing before you take that away. Now we have a situation where we have a benefit unit that for years had been attached to the property and owned by the Setons. The Setons are saying to the district, we own this. At that point, that triggers that due process right. The district has no more right to transfer that to the Lloyds than they do to anybody else. And that's an important distinction because we at the district could not, on a summary basis, just say, here you go, here's a new one, or here's the Setons, we're taking it from them. That could not happen. So this idea that it was discussed as your honors know, as a ministerial issue, that the board could just issue it. Well, that's not the case either. And I talked a little bit about this in the brief, but the benefit unit concept is a little bit more difficult than that because a district is a rural district and it's limited by its system. Some people can live in the district territory and not be entitled to a benefit unit because the water just simply can't get to them. So there is nothing about the fact that somebody could walk in unaided, just one day out of the blue, walk into the office and say, we just moved into the district, we want a benefit unit, and that they hand them a certificate right then and say, well, we'll hook you up tomorrow. That's not how it works. Engineers have to be involved, studies have to be done. If we can't deliver water to them at that location, they don't get one. So this idea that there is just an automatic ministerial vending of these items is untrue. And I think also we need to talk, I guess, bring it back to the question of the law, because my analysis is, and it's in the brief, is that the basic concept here is this, are these attorney's fees, are they a cost or are they damages? Because I think you have to separate those two and figure out, one, what does the statute say about whether they're costs or not? Well, the statute says in this instance that they can be costs if they're under this exception. Now, there's nothing inherent in what the statute on mandamus says that says it's a cost. You need some kind of statute somewhere that says if you incur attorney's fees in a mandamus action, in this action, and that action, it's a cost. And then you put it under the statute that says this is something besides my filing fees and besides my deposition fees, here is the other cost, which is my attorney's fees, which is a line item for $50,000. So in this case, I think that even the Lloyds have agreed that that was not a cost because their bill of costs was submitted in this case. Their bill of costs had their filing fees, And I think it was a total of $241 and nothing else. That alone should forestall this court from awarding that as a cost. So there is no way that you avoid the question, which then turns this into a question of abuse of discretion by Nafziger's court, from the legal situation where there is a statute that says it's a cost, a request for a cost, and then a grant of cost. So we are out of the cost realm. We are now in the case where, are the fees that were incurred, are they a damage? Now that could be the case. We recognize the fact that the mandamus action itself does allow fees in certain circumstances. And I think the court is correct in saying that whatever the source of it is, we have a modern standard. The Barton case, I think, is key in this, that says that this is, in essence, a question of bad faith. And looking at the Barton case itself, I just note that the defendants don't have any individual defendants in them either, and they still talked about it. If it was only a question of individual liability, they would never have talked about it in a case where only the entity itself is brought into the case. But in any case, I think it is the standard that you have to prove some form of abuse, wrongdoing, and other things. And that's where we get back to this question of the offer of judgment. And I think that's the key point of that is that it, like I said, it's the effect specified in the offer. You can't ignore that point because we made a clear offer based upon what we understood would be the solution to this case. Now, if there's one thing I'm going to fight for here, it's going to be the fact that the party who makes the offer has to have control of the offer. They have to be able to say what it is and not have somebody insert things later. If it doesn't say that, you don't get it. You can't use the pleadings to create a right of action, especially one that requires an element of proof that has actually not been found at any trial in this matter. There has been no trial about the bad faith or good faith or what the district knew, what the individuals knew at the time. We made a simple offer. You get your certificates, the matter is settled. And that should have been enough in this circumstance. That's my presentation, Your Honor. I thank you for your time. If there's questions about this or any information I can give you about the benefit unit structure and water districts generally, I'd be glad to do it. That's the argument.
Thank you, counsel. Do we have any questions from the panel? Okay. Thank you, counsel. Mr. Sternberg.
On mute.
You may.
Thank you, Your Honor. I'll try to be brief because we ran into my time before.
That's okay. You've got your full 3 minutes.
Oh, thank you, Your Honor. That was a good presentation by my opposing counsel, but it was light on the law. And to the extent he tried to describe Richardson at all, he's simply wrong. He suggested that by being in control of the offer, if they don't say that they're including attorney fees, then they don't include attorney fees. That is not the law. Here's the quote from Richardson. If the offerer intends to include attorney fees, then it is incumbent upon that offerer to specify that attorney fees are included in the offer. He didn't do that. The point to Richardson is if you don't do that, and yet the plaintiff has claimed attorney fees in their petition, they still can litigate their right to attorney fees. He said that, I had presented most favorably to the Loyds. Of course I did. They took a consent judgment. Everything gets viewed most favorably to the Loyds in this case. The external explanation that Your Honors were given has no bearing on this case at all. All that matters is what's in my client's pleading because they didn't include attorney fees in their offer. He says that he talks about this prior pleading. Well, they consented. If you look at the record, I don't have the page number in front of me, but they consented in volume 1 to our filing the second amended petition. They didn't have to do that. They could have opposed it at that point. All that matters, though, is they made the offer of judgment based on our second amended petition. So that's what they consented to. He says that What's in our pleading doesn't matter because there hasn't been a trial. Well, in an offer of judgment, there's never going to be a trial. That's the point to the offer of judgment. In Richardson, it's a KCPA case. There could have been a detailed trial in front of a jury about a KCPA claim, but there wasn't because there was an offer of judgment. And what entitled the parties there to their award of attorney fees was the fact that the defendant, by doing the offer of judgment, had admitted the KCPA claim and had admitted everything that went with it. Well, here they admitted everything in our mandamus claim, and I appreciate that it was tailored because we then dismissed one of the other claims, but it was tailored to the claim about the issuance of the certificates. And frankly, if they haven't issued certificates to anybody else in the district, although that's not in the record, then they're violating their duty to everybody else in the district too. Their bylaws, it's page 207 of volume 1 of the record, which they admitted to, clearly states that they have to issue these certificates. And the purpose to those certificates are to confirm ownership. And he talks about due process. If anyone's due process rights were violated, it was my client's. My client had this land interest. These benefit units are part of the title of the land. They run with the land, and the district took them away just based on this letter after the sale from the Setons, when my clients had shown them the actual sale documents, and the district simply ignored that. That's arbitrary behavior.
But they didn't actually just simply take them away. Is this, didn't they freeze the account?
Excuse me, Your Honor?
I mean, as far as these units, didn't they freeze the account? Okay, I mean, they didn't say, here, we're keeping these districts, these benefits, and we're going to do whatever we want with.
They transferred
because you were in litigation with the Setons. The Loyds were in litigation with the Setons.
Correct.
A rural water district, they appear to be in the middle and saying, "What? Hold it, we don't know what's going on, so we're going to freeze the account," right?
Except they did know what was going on, Your Honor. That was false. As I explained before, the board claimed at one point that it didn't know who owned the water rights at all, but they did know because Charlie Bowen had already talked to the Setons before the sale, and my clients showed them the sale documents. So they absolutely did know that my clients owned this. They simply transferred them away anyway. That's the problem here. That's the unreasonable, arbitrary, and bad faith behavior in which they engaged in this case, which they admitted to by their offer of judgment. See, we have to keep coming back to that because the district court and my opposing counsel misapprehend the effect of an offer of judgment to the point that he's misstating what Richardson held. The point is they consented to what's in our petition in its entirety. As far as the amount of attorney fees,
Counsel,
yes, Your Honor.
I appreciate you've used up the rest of your rebuttal time, so I'll give you a little bit of time to wrap up, and then obviously see if there's any additional questions from the panel.
Certainly, just extremely briefly. First, we're clearly entitled to costs themselves by the plain statute, and I don't think anyone's disputing that. So at the very least, that has to be reversed. Second, we're entitled to fees either because they simply count as costs under the mandamus statute, or because if we had to show the district engage in unreasonable, arbitrary, and bad faith behavior, we did that in our pleading, to which they fully admitted by submitting an offer of judgment.
Thank you. Are there any other questions before we conclude? Thank you both. You did a great job in your advocacy for your clients in your briefing and in your arguments today. We appreciate it. We'll look over everything.